Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. It was a bit of a slow week on immigration news, so I figured I'll take this opportunity in your trapped ears to promote the American Bar Association's Commission on Immigration and all the great work they do. They did, after all, make me a commissioner. Classic mistake, ABA. Classic mistake. Type in their details into Google to learn all about them for yourself, the ABA Commission on Immigration. In the Commission's own words, quote, "The Commission directs the association, that is the ABA's, efforts to ensure fair treatment and full due process rights for immigrants, asylum seekers, and refugees within the United States," end quote. The Commission advocates immigration issues with the full heft of the ABA behind it. They do a lot. ProBar, IGP, and other nonprofit organizations are part of the ABA Commission on Immigration and are on the front lines of these border issues, representing countless non-citizens, including non-citizen children, for free. They've been at it for years. The Commission also organizes pro bono trips to the border and detention facilities. They have a detention information hotline. They host CLE webinars. And their website provides a litany of very, very helpful practice advisories and policy recommendations to push advocacy and fair immigration policy forward. They do a lot to help us all. Check them out. As for me, well, I've got 3 cases to discuss. Let's go to the First Circuit. Two from the first. First up is Mancia v. Garland, published by the First Circuit on August 4th, 2023. This case is a mess. It's about NACARA. Miss Mancia is from El Salvador. She was brought to the United States without authorization in 1994 at 9 years old to be with her mother, who at the time was seeking asylum. Former INS put Miss Mancia in deportation proceedings, and 11-year-old Miss Mancia eventually had her claims denied and was granted voluntary departure by an immigration judge and the BIA. She did not voluntarily depart. She was 11. In 1997, Congress passed the Nicaraguan Adjustment and Central American Relief Act, or NACARA. Don't forget about NACARA, people. NACARA did many things. As relevant here for Salvadorans like Miss Mancia, NACARA preserved the more lenient relief avenues that predated IRIRA's passage in 1996, like suspension of deportation. And second, it, quote, created a special and more lenient vehicle to reopen removal or deportation proceedings for NACARA-eligible individuals, end quote. The deadline to apply for that latter thing, the specific NACARA motions to reopen, was September 11th, 1998. Long time ago. The rest of NACARA benefits, though, have no deadline, so long as the non-citizen is eligible to receive those NACARA benefits. Enter Miss Mancia, moving to reopen her proceedings in 2021 with the assistance of a creative attorney. She wants to apply for suspension of deportation, the much easier to obtain relief that predated non-LPR cancellation. But see, Miss Mancia didn't meet the suspension of deportation requirements on September 11, 1998. She would now if suspension still existed, and if her case was reopened, it appears, but she didn't back then. The BIA denied her motion to reopen. Miss Mancia wasn't trying to trick anyone. She knew that she didn't qualify for the straight special NACARA reopening with that 1998 deadline. So she asked the BIA to use its sua sponte authority to reopen so that she could nevertheless apply for suspension of deportation under NACARA now. Those would be, after all, reopened deportation proceedings, and again, it would now appear that if reopened, Miss Mancia would satisfy the NACARA requirements substantively, and so she could apply. Still, the BIA denied. It misconstrued Miss Mancia's motion and held that it, the BIA, lacked jurisdiction to consider a time-barred NACARA-based motion to reopen filed after that date in 1998. That was wrong. It always has authority to reopen proceedings sua sponte, explained the First Circuit. The First Circuit disagreed with Oyle's position that sua sponte reopening can't happen if the relief requested below was tethered to NACARA relief that Miss Mancia didn't qualify for in 1998. That NACARA statute of limitations tethered to 1998 was only for those special motions to reopen that traveled under the NACARA motion to reopen statute. Reopening as of right, it would appear. But nothing prevents an IJ or the BIA from sua sponte reopening so that otherwise eligible non-citizens can apply for substantive NACARA relief in reopened proceedings. Fine line, important line, I walk the line. Particularly as, quote, the main purpose of NACARA was to make cancellation of removal and suspension of deportation more available to non-citizens like Miss Mancia, end quote. Whip out those old Central American deportation orders, folks. You might have a NACARA case on your hands and not even know it. Now true, at a minimum, Miss Mancia's failure to depart at 11 years old barred her from suspension for 5 years thereafter. And that was through the relevant motion to reopen time in 1998. But again, that 1998 deadline isn't very relevant to whether the BIA can or should reopen sua sponte now. And of course now that 5-year bar based on Miss Mancia's failure to depart has long since run now. I'm no expert on NACARA, and it admittingly confuses me. And this decision is less than crystal clear. But it seems that Miss Mancia's mother was granted NACARA relief herself in 2006, and that Miss Mancia as a derivative might have become similarly eligible then at the latest, but for her deportation order that she received at 11 years old. The BIA must consider whether that's still the case when it looks at Miss Mancia's motion to reopen again, sua sponte. Therefore, congratulations Margaret Moran for petitioner, and good luck with your NACARA arguments. And that is Mancia v. Garland. Moving on, Bazile v. Garland, published by the First Circuit on August 4th, 2023. This case is about venue and accordingly choice of law. The BIA tackled this issue earlier this year in matter of Garcia, episode 152. The First Circuit is essentially agreeing with Garcia. Mr. Bazile is from Haiti, a country in crisis. He entered the United States as a lawful permanent resident through his father's petition in 1997 at 7 years old. He's essentially a U.S. citizen, right? But he's not. He's an LPR, never naturalized. And he started getting in trouble 20 years after he entered. Firearm and battery convictions, bad stuff. Significant prison time. When he finished his criminal sentence, DHS initiated removal proceedings, just before Haiti's president was assassinated. Mr. Bazile appeared virtually from immigration detention throughout the COVID-19 pandemic, and appeared before a multitude of immigration judges. Quote, the first two IJs were physically present in Boston, but the third IJ was physically located in Fort Worth, Texas. At all times relevant, the petitioner, who was detained, was physically present in Massachusetts. End quote. As relevant to this case, with all witnesses trying to testify over the phone or over a video from prison in the case of Mr. Bazile, an immigration judge denied deferral of removal under the Convention Against Torture, finding that Mr. Bazile would not more likely than not be tortured if returned to Haiti. That final IJ who made that decision was sitting in Fort Worth, Texas. Surely the new virtual adjudication center that EOIR has built in the Fifth Circuit, that, as of today, boasts 17 judges on EOIR's website. The BIA affirmed. Before getting to the merits, who should even be hearing this petition for review? Asked the First Circuit. The First Circuit or the Fifth Circuit? Relatedly, which circuit's case law should apply? It's possible that that Fort Worth judge applied Fifth Circuit law. I'm not sure. Was that proper? Messy stuff. Indeed, explained to the First Circuit, the Fort Worth Adjudication Center isn't actually even an immigration court. It's a virtual center of judges. What are we to do in this modern era? The First Circuit went through the issue by beginning at the beginning. To kick off removal proceedings, DHS must file a notice to appear with an immigration court. But actually, said the first, DHS files that NTA with a, quote, administrative control court, end quote. Not all immigration courts are administrative control courts, apparently. Many are. Some aren't. Now, quote, an NTA ordinarily includes a designated hearing location, end quote. Does it now? As most relevant to the issue here, when it comes to where a petition for review to a circuit should be filed after the BIA denies a case, the statutory language ties that inquiry to where an immigration judge has, quote, completed the proceedings, end quote. So what does that mean, to complete the proceedings? That's what this case and this issue is all about to the First Circuit and to the BIA. Well, quote, proceedings cannot conceivably be completed until the IJ renders a decision, end quote. Makes sense. But that's not tied to where the IJ is physically sitting, said the first. That would be too chaotic. And more than rendering a decision, quote, it is only when the removal order is filed that the proceedings may plausibly be said to have been completed, end quote. An IJ can be sitting anywhere when a removal order is filed. To the First Circuit, then, like the BIA, the only way to resolve this mess is to tie it all to administrative venue. Quote, administrative venue is defined by regulation as the court where proceedings commenced when the charging document was filed unless a formal change of venue has been effected, end quote. That is, in the administrative control court where the NTA is filed, unless an IJ subsequently transfers venue. Matter of Garcia, agreed with. Because, of course, the Fourth Circuit and some other circuits do not agree with Matter of Garcia, albeit in pre-Garcia decisions. Also, in a footnote, the First Circuit notes that it and the BIA have never decided what happens if the administrative control court and the hearing location designated in the NTA are in different circuits. A, quote, wrinkle, end quote, yet to be resolved, however unlikely. Also, can't help but note that so many deficient NTAs do not identify any court at all, because they're deficient. Seems nuts to possibly tie venue to NTAs not being deficient, given everything that's going on at the moment. Anyway, in this case, all of that was the Boston Immigration Court, and that's in the First Circuit. Doesn't matter that the final IJ was in Fort Worth. That means that all of this is properly before the First Circuit. On to the merits of the cat denial, then. Denial affirmed, under First Circuit precedent. To begin, notwithstanding Mr. Bazile's criminal history, the First Circuit can review the factual findings made by the agency under substantial evidence review. Thank you, Nasrallah. Didn't save Mr. Bazile, though. Quote, here the petitioner asserted that if removed to Haiti, he was likely to be tortured based on his family's, and particularly his father's, past affiliation with the Lavalas party. The record reflects that Lavalas was a political party and that its supporters were targeted by opposition parties during the political upheaval of the 1980s, end quote. And everyone agrees that Haiti is in, quote, the midst of political turmoil, end quote. Indeed, a respected report that I read today reports that most of Port-au-Prince is controlled by gangs, and that those gangs have ties to government officials in Haiti to the extent that a government exists. The Department of State has also ordered family members of employees and non-emergency personnel out of Haiti because of yet another kidnapping of U.S. citizens that just happened. But that stuff isn't happening because of any animosity towards Lavalas, apparently. All that Lavalas stuff all happened 3 decades ago, explained the First Circuit. Nor could Mr. Bazile show that he was at particular risk now, having grown up in America. All the evidence Mr. Bazile presented was just too generalized, said the First Circuit. Hard to do otherwise when you've been in the U.S. so long and you don't present an expert witness, and when you're in immigration prison. Quote, general evidence about country conditions cannot compensate for the lack of specific evidence showing a particularized risk of torture, end quote. For what it's worth, in, say, your asylum or non-LPR cancellation of removal cases, though, quote, the record shows that danger and violence are endemic in modern Haitian society, end quote. But Mr. Bazile did not succeed. Back to venue for a minute, if you'll join me. As I mentioned, the circuits are kind of all over the place on where to petition for review these multi-jurisdiction cases and what circuit law to apply. Check out the rundown of circuit explanations in this decision. But to summarize, the Second Circuit says it's in the court identified in the notice to appear. The Fourth Circuit says it's where the IJ was physically sitting when he or she completes the proceedings. The Seventh Circuit says that it lies with the court where, quote, all parties were required to file their motions and briefs, end quote, and where, quote, the orders were prepared and entered, end quote. The Ninth Circuit says it's the hearing location identified in the NTA or initial hearing notice. The Tenth Circuit considers a variety of factors. I feel like also that there was a recent Third Circuit decision, right? And that it essentially said what the BIA then said a few weeks later in matter of Garcia. Not cited in this decision, but there you go. And that is Bazile v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. Our final decision this week is Arostegui-Maldonado v. Garland, published by the 10th Circuit on August 1st, 2023. This case is about withholding-only proceedings, and it's a heady one. Mr. Arostegui-Maldonado is a citizen of both Costa Rica and El Salvador. He was removed to one of those places in 2008, but he re-entered the U.S. without authorization in 2021. DHS therefore reinstated the 2008 final order of removal, after which Mr. Arostegui-Maldonado asserted that he feared return to both of those countries. That got him into withholding-only proceedings, where an immigration judge and then the BIA denied his claims. So yeah, I guess I'm about to do 2 withholding decisions. First, El Salvador. Mr. Arostegui-Maldonado testified that he feared returning to El Salvador because his uncle sexually assaulted him there in 1994. He also said that he feared conditions of crime and violence and referenced a 2012 incident when a gang member threatened him and shot his brother. On to Costa Rica. Mr. Arostegui-Maldonado testified that Costa Rican police officers harmed him in 2020. He stated that on November 24, 2020, 2 officers confronted him at gunpoint at his home and demanded that he sell drugs for them. Quote, he said the men arrived in a patrol car and wore police uniforms, though they did not explicitly identify themselves as police officers. Mr. Arostegui-Maldonado said he reported this encounter to the police. End quote. But then, uniformed police confronted him at his home later, including at least one from that earlier confrontation a month prior. Quote, the officers took him at gunpoint to an isolated location and severely beat and raped him. They again demanded that he sell drugs for them and threatened to kill him if he reported their actions or did not comply, end quote, and they threatened his family. He fled in fear a few days later after repeated harassment and threats from police. Apparently, there is now an arrest warrant waiting for him in Costa Rica. The immigration judge denied and the BIA affirmed simply by adopting the IJ's decision. Mr. Arostegui-Maldonado only challenged cat denial before the 10th Circuit. And he succeeded. But first, jurisdiction. Jurisdiction. And yes, this is oil trying to expand very bad precedent for non-citizens from the 2nd Circuit and very recently from the 5th to the 10th Circuit, like a virus. The 10th Circuit did not take the bait, thank God. I talked about this issue 2 weeks ago in Argueta Hernandez from the 5th Circuit. Essentially, the 5th and to a large extent 2nd Circuit believe, following the Supreme Court's Nasrallah and Guzman-Chavez decisions, that those circuits, lack jurisdiction to review denials of withholding or cat protection in withholding-only proceedings following reinstatement, because a denial of withholding or cat doesn't result in a final order of removal. That's how the 2nd Circuit and the 5th Circuit read Nasrallah and Guzman-Chavez. Rather, to those courts, the final order of removal is what happened all those years ago in the cases in chief that DHS is now reinstating. In effect, the 5th Circuit's rule at least prevents non-citizens from ever getting federal court review of denial of withholding of removal or cat protection in withholding-only proceedings following reinstatement. Because that challenge will never come 30 days after the final order of removal that's being reinstated, and that is always many years old. So not a great jurisdictional rule for non-citizens. Circuit court petition for review jurisdiction is tied to review of final orders of removal. That's why all of this is so important. If a denial of withholding of removal or cat protection in withholding-only proceedings is not a final order under the INA, non-citizens have big problems. No dice, said the 10th Circuit. Because as the 10th Circuit has said multiple times, quote, an order reinstating a prior removal order is the functional equivalent of a final order of removal, and, therefore, we have jurisdiction to review the reinstatement order, end quote. Why are you trying to make such bad law, oil? You know that's not what Nasrallah and Guzman-Chavez expressly said. The 10th Circuit went on to explain that this is in part because, quote, the rights, obligations, and legal consequences of the reinstated removal order are not fully determined until the reasonable fear and withholding of removal proceedings are complete, end quote. As to Nasrallah and Guzman-Chavez, well, first off, those decisions literally had nothing to do with the legal question at issue here, said the 10th Circuit. But second, the 10th reads its precedent consistently with the Supreme Court's rationales. It's not that, quote, the BIA's disposition in the withholding-only proceedings would itself be a final order of removal. We said that the culmination of the withholding-only proceedings would render the reinstated order of removal final, end quote. To summarize, it's not final till it's final. Even if the denial of withholding of removal and cat protection isn't a final order of removal anymore, cat denial itself is still reviewable, as it was in Nasrallah itself. In fact, Nasrallah made it easier to review. That the cat review in Nasrallah traveled alongside a final order of removal and didn't occur after reinstatement is of no consequence to the 10th Circuit. At a minimum, the 10th wasn't so sure that this Supreme Court precedent overruled its prior precedent. So under circuit rules, the panel can't overrule other panels. All of that just to get to review of what the IJ and the BIA on cat in this case. Remanded! A cat applicant must show that it is more likely than not that he or she would be tortured if removed to the proposed country of removal. And here that's 2 countries. Cat protection is mandatory if established, and there is no pesky requirement that the harm feared, here torture, be on account of one of those 5 protected grounds required for asylum and withholding of removal. But the government actor prong is generally more difficult to meet. If the country's government isn't the torturer, rather than showing that a country's government is unable or unwilling to protect from private actors, CAT requires that the country's government acquiesce or consent to those private actors' torture. In this case, though, and at least with Costa Rica, we don't really have that issue. Because here, right, Mr. Arostegui-Maldonado feared police officers themselves. That's a public officer. And if they're, quote, acting in an official capacity, end quote, then they satisfy the government actor prong, what we call the under color of law standard. And in what might be the only non-citizen-friendly asylum CAT-type claim during the Trump years, Attorney General Barr said in matter of OFAS that a, quote, act is under the color of law when the actor misuses power possessed by virtue of law and made possible only because the actor was clothed with the authority of law, end quote. Episode 12. End quote, when police officers inflict torture, it is irrelevant whether the police were rogue in the sense of not serving the interests of the entire government or not. The relevant question is whether they acted under color of law, end quote. Get it, Attorney General Barr? Get it. The IJ held here that the under color of law prong wasn't met. The 10th Circuit disagreed. Mr. Arostegui-Maldonado's, quote, credible testimony established that the officers wore their police uniforms, drove a marked patrol car, held him at gunpoint, handcuffed him, arrested him, brought him to a government jail where he was held for 24 hours, and later issued a warrant for his arrest, end quote. Seems like corrupt cops. And that cuts it for CAT. The IJ believed otherwise, saying essentially that it could have been anybody. Quote, under the IJ's rationale, because a private citizen could have held Mr. Arostegui-Maldonado at gunpoint, abducted him in a vehicle, and beaten and raped him, it made no difference that uniformed police officers held him at gunpoint, abducted him in a patrol vehicle, beaten, raped him, jailed him, and obtained a warrant for his arrest. This interpretation defies logic and the law, end quote. Attorney General Barr mandates a conclusion contrary to the IJ. OFAS for life, explained the 10th Circuit. The 10th Circuit made quick work of a bunch of other arguments and remanded on the government actor analysis thing. Therefore, congratulations Laura Lund for petitioner, alongside pretty much everyone and their mama on amicus, including that organization near and dear to my heart, Immigrant Justice Idaho. Not gonna lie though, it seems that Mr. Arostegui-Maldonado can be removed to El Salvador, but just not Costa Rica. Still a win for Mr. Arostegui-Maldonado and non-citizens, don't get me wrong. But I wonder if removal to El Salvador is practically difficult here for some reason. Undiscussed. Anyway, congratulations, Mr. Arostegui-Maldonado. 2 more things before I go. First, not so fast on that initial jurisdiction thing. That is, reviewing withholding and CAT protection in reinstated withholding-only proceedings. 2 of the 3 judges on this panel concurred with themselves to urge that the 10th Circuit go en banc to review if indeed the 10th Circuit's old precedent is no longer good law in light of Nasrallah and Guzman Chavez. Sigh. But to end on a positive note, in a footnote, citing some podcast faves, the 10th Circuit notes that counsel submitted a 28J letter arguing that, quote, whether the government acted under the color of law raises a legal question that receives de novo review, end quote. That's a big deal argument, and the 10th Circuit agreed in a footnote. Quote, the standard of review for the application of law to facts for CAT determination is de novo, end quote. That is a big quote with potentially big applicability. That is, big. And that is Arostegui-Maldonado v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.